briefly before I sit down, and that relates to agents. Did you have more than one agent in any of the 166 polling stations?
I don't need one agent and the list of agents for one.
Which is at page 153 of the petition. Those two forms, Mheshimiwa, are the standard that all of us filed including yourself. You can tell the court the polling stations in respect of those two from 35 days, starting with the one at page 42.
I can see Aegis here, DOK primary. 203.
203. You can also look at the other one at page 153 of the petition, the form 35A at page 143 of the petition. Which polling station does it relate to?
That's this here, the primary. 102.
Yes. How many Jubilee agents have signed the form at page 42 of the petition?
That is in respect of which station?
ABC primary DOK.
1 or 2?
Two, my brother. Yes. How many Jubilee agents have signed the form?
My Lord, I can see 2 people signing in the name of Jubilee.
2 people are signing the form. How many people signed under Jubilee in the form in respect of Isiaga, DEB Primary School, polling station 1 or 2?
I can also see 2 names appearing as Jubilee.
Which party sponsored you, Mheshimiwa?
Jubilee.
Jubilee. What is your explanation now that you had one agent in each polling station to these 2 stations, and an example of 8 others, where 2 Jubilee agents signed the form 35A?
One explanation could be that some agent decided to associate with the winning candidate, Jubilee, and decided to sign with the other. But I have put a list of my agents at Egesieri and Egesiaga that you have brought to my attention, and those agents signed. If others chose to also call themselves Jubilee, the merrier.
Thank you, Mheshimiwa. So that it's possible that for you candidates, the primary forms from the polling station, there are people that sign that are unknown to you. That's a possibility. It happens. Does it happen?
Sorry? Let me get the question.
My question, my Lord, is that because Mheshimiwa was sponsored by Jubilee, I was asking him to confirm.
Conversely is I believe conversely is the same argument. Yesterday we were treated to several stations. I cannot remember how many, where we had more than one ODM agent signed.
Yes, yes.
So the same explanation we want to go for the other side.
Yes. Okay. Yes. So, Mheshimiwa, that it's possible that there are people that can sign forms.
I think we are entering into a speculation.
Yes.
Because they have work on station. No, we don't have to speculate. Mr. Ochoki.
Fine. So you confirm, Mheshimiwa, that there were strangers, or so to say, that signed the forms in your name.
Did he say so?
I will say so.
Signed forms
I think
Let me clarify, my lord, I've heard you. Mheshimiwa, what I wanted to say was sponsored by Jubilee. Ordinarily, we'd assume that the Jubilee agent signs the form 35A for you. Is that correct?
Yes, the
Based on the forms that
Jubilee accredited the agents who represented me at the polling station.
so that based on the forms that I have shown you, Mheshimiwa, these were sample forms. There were people that signed the form 35A on behalf of your party, possibly without your authority or knowledge.
That is not my party. It is the party that sponsored me.
The
It is
party
not
that
mine.
Yes.
And therefore, may I kindly answer as to whether my agents filed in this court signed that form. If that agent signed, that is the authentic agent for Jubilee.
Finally, Mheshimiwa, the fact that two Jubilee agents sign does not invalidate the contents of the form, does it? Does not make the forms 35 that are signed by more than one agent invalid.
There's a provision for 20 people to sign them.
Does it make the form invalid?
I doubt.
You know, you are entering into a technical area. That was for the presiding officer.
Thank you.
And I think, if I can recollect, they asked that.
Thank you, thank you. I just wanted the witness to clarify, and with that, my lord, from the petitioner, we are done with the third response.
Second, first and second, sorry, Mr. Khalid.
Mheshimiwa, could you go to your third response? Document.
Respond for affidavit, which so that it is clear to you.
Your replying affidavit, page 8 of the next chapter, it's a gazette notice. Next one. You're there?
Yes, my lord, I am.
Page 8, yes. What is that you're looking for? You're looking at the gazette notice that announced, a gazette notice dated 23rd of August 2022, isn't it?
Yes, it is.
Entry number 46 on that page 8. Can you see entry number 46?
Yes, I can.
The gazette notice claims that you had actually announces, not the claim, declared that you had won by how many votes?
My lord, the published results are 17,097.
From the gazette notice.
From
That
the
is
gazette notice.
how many?
17,097.
17,000.
97. 097.
Do you have a copy of the petition there? Let's look at paragraph 7. Is it that one?
Only a response.
Would you go to paragraph 37 of the petition? The petitioner claims that the votes he garnered was 16,877 votes, isn't it? That's what paragraph 7 claims. That you garnered 16,877 votes, isn't it?
I see so.
16,000.
877.
Yes.
So there's a variance between the numbers quoted in the gazette notice and what the petitioner claims in this petition, isn't it?
Yeah, these are foreign numbers.
Is it one of the reasons you want this petition to be dismissed? That they have quoted the wrong figures to begin with?
Yes, indeed, my lord. There is no petition against my 17,097 votes.
Yes.
You are asked extensively about the variance of votes, total votes casted between the positions of MP, cast, my English, cast between the position of MP and MCA. Were you asked on any question regarding the valid votes between the for the petitioner and for the that respondent? Was there any discrepancy on valid votes, not total votes cast? There was none, isn't it?
Yes, no, my lord, I have not been asked
On valid
anything between my votes and that of the petitioner.
Is it what he has been asked or what?
I am putting it to
You know,
you.
you are losing us, Mr. Kamini.
I am putting it to you that there has been no contest in the petition. You are opposing the petition, isn't it?
Yes, I'm opposing it very vigorously.
Yes, and my question is this. The petitioner has not claimed that there was any difference, any error in the valid votes cast for you or in the valid votes cast for the petitioner. There was no error at all that he has claimed in the petition. Would you agree?
Yes, I agree. I have not been questioned.
And even in the petition, the issue is not on valid votes.
It isn't. It is about MCA elections.
Thank you.
Remember house rules. You have kukuza wote tubaki peke yetu.
Now,
Na kesi itaendelea. So that we don't relay the witness.
you have also been told that the IEBC, my client, made several errors in transposing results from 35A to 35B. Now I want to take you to from 35A, Giri 1. Showing my window. Page 63.
Yes.
Are you there on page 63 of the IBC document?
Yes, I am.
What are you looking at? The Form 35A for Girigiri, the primary 1, isn't it?
One of two.
Yes. Now, look at the entry for the petitioner, number 10, Moturi Ongera Rogers. How much is he shown to have garnered? 257 votes, is it?
Yeah, it appears 257.
Okay, now go to page 177 of that same bundle. Just put your finger there.
You say 250?
257, my lord.
So in Form 35A, it is 257 for the petitioner. Now put your finger on page 177. Don't close there. Go to page 177. Could you, I don't know, those numbers are terribly small. Could you go to Girigiri 1? This is the form, what are you looking at? Form 96B, isn't it? Look up, would you? 35B. You're looking at Form 35B, isn't it?
Okay, yes, sir.
Yes,
Yes,
this
go
is
ahead.
from 35B.
Okay, good. Now, if you go down, you will find Girigiri DG primary 1, somewhat in the middle there. Have you spotted it?
Yes, I've seen it.
Now, go to the entry for the petitioner, Moturi Rogers. Again, it's somewhere in the middle. It shows a figure of 251. Yes?
You see, let the answer come to me.
I'm about to leave.
Yeah, you are not to leave, but you see, what else?
I don't think there's an extent.
I don't want to capture what you are telling me, but I want to capture what is telling me.
My Lord, I can see the figure is 251.
Okay, there is a difference, therefore, of 6 votes. Only 6 votes
Yes, there is a difference of 6 votes.
between Form 35A and 35B.
5B.
Yes.
So the petition has only lost in that station. Only 6 votes for all, in all the 100, I put it to you, that the petitioner, the only error in Form 36B, in 35B, in relation to the valid votes for the petitioner, was only in Girigiri 1. Would you agree with me?
Yes, my Lord, I do. Although there are some alterations in 35 days,
Yes.
it might have originally appeared as 251, as is captured on Form 35B.
Yes, we saw the overwriting, yes.
There is an overwriting.
Yes. I think
Therefore,
this-
assuming in 35A, it ought to have been 257, and since 251 is on B, then obviously there is an understatement by 6.
Yes. And my point is, as for the ABC, it is only in that station that there was a transposition error in relation to the valid votes for the petitioner. Out of all the other stations, only in that station. Do you agree?
Yes, certainly, I can agree
Okay, let me
on account of the petitioner.
let me take you to Kenyanya 2. Where should I have invited Kenyanya? Come on. Page 32. Go to page 32. You there?
Yes, my Lord, I'm on page 32.
You are looking at Form 35A in respect to Kenyanya Polling Station 2.
2 of 2.
Okay. Entry number 7 for you. The entry is 158 votes for you.
Yes, it is 158 in my favor.
Okay. Again, go to page 177. And look for Kenyanya 2. It is at the page 177, the second last, the penultimate entry from the bottom.
And
Yeah.
Kenya,
Yes, go to your own entry.
it is
159, isn't it?
read as 159 here.
So there was a transposition error from Form 35A to 35B, where you lost only 1 vote. No, you were added, sorry, only 1 vote, isn't it?
Yes,
Mr.
I-
Kennedy is testifying.
I am leading.
But there is a difference between leading and testifying. So that as you lead, it does not need
That
to be
is
the
what I
answers
was
are
alluding
coming
to,
from you.
but
I am winding up the motion.
my Lord,
yeah, avoid the testifying. So
I am-
that I
I
also
won't-
catch
I won't testify.
and capture what the witnesses.
I won't testify, Your Worship, but I am allowed to leave. So, at the entry in Form 35,
You don't need to argument. Ukicorrectiwa, this profession, you have to be ready to be corrected. Tuulize hata sisi tunacorrectiwa. Tunaambiwa hapo umekosea. We are shown our mistakes. Lakini wewe tunakuonyesha vile unatakiwa you still insist. How will you learn? You learn by mistakes. You make a mistake, you are corrected, you don't repeat the same.
I am ready to be corrected, Your Worship. But I'm not ready to give up my client's right to cross-examine by leading.
Mr. Kale.
The law is there that I can lead.
Mr. Kale, I know this. I know this. All we are asking, don't testify. Ask the witness, let him give us the answer. I can record the answer of the witness, not of your witness. So you are doing your plan answer, by the way. Because if you is just yes, I just record yes. No, it doesn't yes. Let me capture the answer from the witness.
So how many votes did you lose by the transposition error between Form 35A and 35B?
My Lord, I appear to have got an extra vote during that transposition, for which I regret, and if it belongs to the petitioner, it can be given back.
The difference in the votes, the difference in the votes garnered between you and the petitioner was over 500 votes, isn't it?
It's actually 573, to be precise.
Yes.
So that one vote that you've been added there cannot make a difference in this petition, can it? The 6 votes that the petitioner was denied in Girigiri 1 cannot make a difference in the difference between the petition and you. Only 6.
Yes, the error that understated the petitioners votes by 6
cannot make a difference in the difference of numbers.
Yeah, is immaterial.
All right. Let me go to the next question. Again, you are led extensively on a comparison between the MCA votes, the MCA total votes cast between the MCA and the MP. And you say one of the reasons there could be an error, a difference, is stray balance. You say that, isn't it?
Yes, that is what I respond to.
Can there also be a difference in the total votes cast between these two positions because of transposition errors?
Yes, like as appeared in Kenya.
Yes.
Transposition is one possible explanation for the discrepancy.
But those errors still cannot change the fact that you won by over 500 votes, isn't it? As I have shown you.
Yes,
I think that one can wait for your submissions. Let's go to the facts.
Indeed, if you go to Nyamira, if you go to Nyamira 4, Nyamira 4 is on page no, you look at your table. Where's the go to page 178. Of the IBC document. Are you there?
yes, I am.
What are you looking at? Form 35B. Yes?
I'm looking at Form 35B
In respect of
in respect of
Form 35B as all entries. Now,
yeah, but which entry in particular?
okay. Somewhat in the middle. Can you pinpoint it?
yes, I'm there.
So, what are the total votes? What are the total valid votes cast? 429, isn't it? At the end. Nyamira 4.
Two very small prints.
Yes, terribly small, I know.
Which Nyamira?
Nyamira 4.
Nyamira 4.
Yes, I want to look at valid votes cast at the end. It is indicated as well. 429 votes.
429.
I can lend you my ruler
Kind
if
of,
you misplaced yours.
so kind of.
You've seen the figure of valid votes. Of valid votes. I'm yet to ask you about total votes cast. Valid votes is how many? 429?
Nyamira 4, there is a figure of 429 appearing.
Okay. Rejected votes, just next to it is how many votes? 4 votes, isn't it?
There is a figure of 4.
Okay. When you add 429 and 4 comes to
Comes to 433.
433, isn't it?
Yeah, 433.
For MP. So the total valid votes, total cast votes for MP in Nyamira DB4 was 434. 433.
433.
Okay. Now go to page 187. Just put your finger there and go to page 187 of the same bundle. Nyamira,
Yes, I am.
what are you looking at? From 96B. Isn't it? Look up. What is that?
Here is 36B.
Okay, now go to the 96B is in respect to the MCA election, isn't it?
Yes, it is.
Okay, now go to Nyamira DB4. Somewhere in the middle. Terribly small.
If you now appreciate when we talk about you copying documents that are legend, what you mean. We also follow the same thing with rulings and judgments.
Okay, the form was so big, it couldn't be photocopied by the scene and video. It was an A3 form.
But you've given him something that's as larger. Just move on.
Now, if you go to Nyamira DB4, you there?
Yes.
Yes. What is the total valid votes? Valid votes. We come to the rejected and the cast. Valid votes, nominee.
The two valid votes appear 100.
The next entry, how many? 5 votes.
It looks like 5, my lord.
Okay. We add 430 and 5.
435.
So indeed, there are cases where the MCA total valid votes are more than the MP votes. Like,
Also MP.
like in this case, isn't it?
Yes, indeed.
Yes.
When were you there at the tallying station? Actually, he said you didn't see him. Huh? Did you see the petition at the tallying station? He said no. Okay, then I have to forgo that petition. Nyamira, I want you to go to page 21 of my document, of the ABC document.
That is about Nyamira 203.
Actually, yes, Nyamira, you're looking at from 35A, isn't it, of Nyamira 2?
2, yes, 203.
What is the entry for number 11 on the list? Nyamanga Eric Achoki. Nyamanga Eric Achoki.
001.
001. Now go to page 178. Again, you may need the course for you.
Yes.
What are you looking at? From 35B, isn't it?
This is from 35B, yes.
Yes. Now, Nyamira 2. Look at the entry for Nyamira 2, somewhere in the middle. And go to Nyamanga Eric Achoki. Do you see an entry for 56 for him?
It is an entry of 56 years, my lord.
But in the from 35A, we saw an entry of 1.
001.
Yes.
So the total votes, so the difference between 56 and 1?
55 votes.
So the MP votes, total votes cast were extra. One of the reasons is that transcription error in relation to Nyamira 2. Wouldn't you agree?
Yes, certainly, this is a major, a material number that we got.
So when the petitioner claims that because of this transposition error, there were extra ballots issued, is that claim valid?
No, there couldn't be any extra ballot issue. At least to the extent I know, I got only 6 ballots.
You claim, you stated that in the tallying center, there was an ODM agent at the tallying center. You were asked whether you saw the petitioner's chief agent, and you said you don't know him, but you said there was an ODM
Yes,
agent.
there was an ODM agent, Polycarp.
Oh, you know him, that's what I was going.
Yeah.
You know him personally.
Polycarp.
Do you know the other name?
No, I know that it's a medic.
Okay, he's a doctor.
It's a medic, not a doctor.
Okay, but his name is Polycarp, you can't remember that.
I can't remember the other name.
That's very important.
I even know where he comes from.
But he was in the police. When he went, he found him there.
I saw his face there, and I noticed his ODM agent because he asked a question about some ODM, something about ODM in respect of.
After the captain, don't explain, please. Those are the rules of the game. Let's move on.
He answered that question. He posed the question to the presiding officer, to the returning
To
officer.
returning officer, I saw an engagement.
Okay, but you didn't understand what it was.
Yeah, I didn't follow. I was far from it.
Now Mr. Matoki asked you whether you were there on the two announcements that were made. Do you understand there's a difference between an announcement and a declaration of the final winner?
Yes, I do. I do understand the difference.
How many declarations were made by the returning officer of the final winner?
It's a single declaration.
Thank you very much. Thank you very much for your questions, and I congratulate you.
You are good? Okay, and re-examination.
The areas that we want to cover will come out. We have no re-exam.
Thank you. You may sit.
third respondent's case. And the bomb back to court for further directions as to the balance of the other activities that is necessary. I'm saying I'm handing this back to court for directions as to the balance of the other activities that is supposed to have undertaken, including the kind activities.
Yes, I may now be addressed on the issue of recount and scrutiny, and I said each party will be given 5 minutes only to highlight, because we have already put in submissions, we do not need to reproduce them. So, Mr.
Just one issue, my lord, just one issue.
Yes?
Before Mr. Ochoki addresses the court.
Oh, I called you a joke, so it's a joke.
Yes, yes. No, there's an issue regarding this application.
Sorry?
There's an issue regarding this application.
Yes.
And that on the 14th of October, and the court recorded any witness.
Yes.
14th October, Mr. Ochoki abandoned the question of scrutiny. It's on court record.
Oh, so it's only a recount?
Yes.
I don't
Let
know why.
me just confirm if I... Just confirm, Mr.
I don't want to swear, but I did not abandon the issue of scrutiny. We wish you to render.
Okay, just a moment. Let me look at what Mr. Ochoki. You said 14th of October?
Yes, my lord.
I will not abandon
For me, just because you have said you did not, and they say you did, that's why I'm looking at the record. So why don't you give me a few minutes, because I'm on 14th of October, just to see what transpired therein.
Perhaps, my lord, it may require that the court goes to what each and every one of us said, because I remember I followed soon after the...
Yeah, that's what I'm doing actually, to see whether at a later stage, because initially he said they have an application dated 29th September, they are seeking recount and scrutiny and examination of diary and Kim's kit amongst other materials. Then I was addressed by the rest of you. Let me just find out if at a later stage he... And you said that was on 14th?
In fact, it's there when Ochoki said yes.
No, it's okay, it's okay. I'm looking at the record. That's why I want to be sure that it's only 14, so that I don't check it elsewhere.
Somewhere at the bottom.
At the tail end?
Yes.
At the tail end, this is what Mr. Ochoki told me, that Rule 16.1 should not be elevated to undermine the cause of justice. Article 159 of the Constitution looks at the substantive justice. That was after the rest of you had addressed me. I've gone through my record. I don't seem to see anywhere where you are.
My lord, this is where perhaps transcription also could help, because I remember he stated, perhaps maybe that it will require that also you indicate what we also said in the application in response to what he did. Because we are very clear that he abandoned that application.
My Lord, if I may respond, because I've been present in his proceedings the entire time.
Yes.
What happened, my Lord, is that when we were seated and he would ask whether I am seeking for scrutiny, I believe off record.
Okay. Sorry. I think I'm getting a place which I attributed to me after Mr. Nyamira said we have responded to the application. I think my record erroneously quotes Mr. Nyamira twice saying we shall abandon prayer for scrutiny and only embark on the count. That was meant to be you, but unfortunately, that's why I think I captured to be Mr. Nyaberi saying so. But he could not be saying so.
Transposition.
Yeah, that is a transposition error actually from 35A in the mind to the paper.
My Lord, then,
Yes.
the court is going to attribute that to me, then it's...
No, not attributing. Actually, the sequence will tell. You know, when we record these things, at times we even go through and make corrections. Because this is a typo.
My Lord,
If I may be allowed to use the typo, because I'm not typing.
then if it's me, it's also a typo, my Lord. I had no instructions, my Lord, to withdraw any application. Because my client has been present the whole time, I could not do it without instructions. And I think
I believe you guys are putting submissions.
I don't know why they want to...
Oh, okay, just a moment. I believe parties have put in submissions.
We have.
I'll be guided by the record and the submissions that you put in. And my asking you to do a 5 minutes highlighting is only to capture areas which you do not want the court to lose sight of, so that I don't an injustice, so that we do not belabor the point.
So that, my Lord, then what
Yes.
is left for us to tackle or address you on
Yes.
is the recount and not scrutiny.
Just address me the way you, because he's saying he did not, you are saying he did, my record says otherwise.
My Lord, there's no an application for review of those orders. That's
So you see what
considered.
I'm saying, Mr. Nyaberi,
Yes, my Lord.
parties had already, by this time, put in submission. You are not putting in your submission now. All you are doing is just highlighting. I will be guided by the record as I'm just.
My Lord, the importance with which they are trying to convince you that
They are not convincing me on
that
anything.
I withdraw the application for scrutiny is misleading. If, my Lord, I wish you to, the court to come clear on whether, according to the record, I withdrew that application.
Please, I've just told the parties to address me and be guided by the record. Because he haitatupeleka mahali, tutaargue forth to
My Lord, it's extremely important
Please.
so that if the
kindly
record...
highlight.
My Lord,
Please, Mr. Ochoki, we are not going there. We are not opening that again.
thank you.
Kindly address me, and I'm giving each party only 5 minutes because you've done your submission. You know, if I was going to tell you to write submissions afresh, I think that will be relevant. But I'm not doing so. All we are doing is highlighting. So you start, Mr. Ochoki, sorry, Mr. Ochoki, and then
My Lord, as I start, there isn't decisions from your colleagues that have been rendered after we filed our submissions. Your learned sister, Lady Justice...
why don't you do this, Mr.
Yes.
Ochoki? Even if you wish to do additional
Yes.
authorities, is okay, is allowed, but why don't you start highlighting? I will give you only 5 minutes. I'll give you 5 minutes.
Thank you, my Lord.
Yes.
The application before you, my Lord, is dated 29th of September 2022. My Lord, it seeks for the avoidance of doubt, recount and scrutiny of all the votes in the polling stations outlined at prayer A. We will also,
So in the
prayer A, the polling stations outlined in prayer A of that application. We will also be seeking, my Lord, prayer B, C, and D of that application.
yes.
My Lord, we had filed our submissions on the 21st of October, 2022. I'll be relying entirely, my Lord, on those submissions And I will be requesting or begging my Lord that you allow me to pass on to the court two decisions by your learned sisters on the same point, same prayers, my Lord. I'd sent the same to my colleagues on email, but they relate to two petitions, my Lord. The first one is Kajiado election petition number 1 of 2022. That is Paul Karembu
Yes.
versus IBC and 4 others, where, my Lord, Lady Justice Mulwa, on 10th of January this year, allowed an application similar to ours. Allow me also, my Lord, to rely on the decision in petition 1 of 22 at Homa Bay. That is Evans-Kidero versus IBC, also and 5 others, where on 18th of November 2022, Lady Justice Aburile, my Lord, allowed an application exactly similar to the one before you. My Lord has heard the witnesses, including the one that has just left the door. Elections, my Lord, are about numbers. The numbers do not add up. A recount will never help. My Lord has discretion even on your own motion.
2 minutes.
My Lord has discretion even on your own motion to order scrutiny of the election materials as outlined in this application. Kindly allow the application so that the people of West Mugirango, my Lord, will be able to know who won the election of 9 August 2022. And just for emphasis, my Lord, a recount will not help. Scrutiny will. Kindly allow scrutiny. Thank you.
I'm going to rely on the submission filed by Senior Counsel Moturi on the dated 31st of October 2022. On the 31st of October 2022. And in particular, on the question of what is the guiding law, the Supreme Court, no less than the Supreme Court, as ruled in the case of Gitaru Peter Monya versus Dixon Mwenda, 2014 KLR, on the principles and the guidelines applicable for scrutiny and recount, although there's not issue of scrutiny there. But that case is the leading case coming from the Supreme Court. And it says it's only in exceptional circumstances, exceptional cases, that scrutiny and recount will be allowed.
Yes.
Then, from the evidence given in the days we've been here, what is that exceptional thing we have seen? What is that that has been testified to warrant scrutiny? I submit, Your Lordship, that this is a case that could have been disposed of by affidavit evidence, because the documents speak for themselves. If there is an error in Form 35B, you can see it. If it is in 35A, transposition error, you can see it, without even calling that witness. What then is exceptional? Everything that was raised could easily be explained by the documents. even without calling the witnesses.
Yes.
I therefore rest and ask your Lordship that you be well pleased to deny the prayer.
Well, on behalf of the third respondent,
That is Mr.
yes, Mr. Mokwa. But on behalf of the third respondent, we rely on a reply affidavit filed on the 13th October 2022 by the third respondent and the written submissions filed on the 28th October 2022. My Lord, we submit by indicating that on the 14th of October, the prayer for scrutiny was abandoned as per the court record. And on the first port of call, my Lord, we refer to Rule 8, Sub-Rule 3, Paragraph B of the Election Petition Rules 2017. My Lord, the same was amended to include that
The same rule?
Rule 8, Sub-Rule 3, Paragraph D for dog, of the 2017 Election Petition Rules. And of these rules, they were amended to require in mandatory terms, if a petitioner is seeking scrutiny and recount, it must be pleaded. There must be that prayer. We submit there is no prayer for scrutiny and recount in the petition. My Lord, secondly, on the issue of recount, my Lord, we refer the court. Yes, it is a submission that recount cannot be granted because according to Rule 28, Sub-Rule B of the 2017 Election Petition Rules, recount can only be granted if the only issue in the petition is the tally. In this petition, we have allegations of violence, allegation of intimidation, allegation of improper influence, allegations of bribery, so recount is not the only issue in this petition. Now, my Lord, there are two circumstances where scrutiny and recount ought not to be granted. And one of those circumstances is to be found in paragraph 4A, where the court can make an paragraph 4A of the third respondent's replying affidavit. We violated the two circumstances, one being where the court can make an informed decision based on the material before the court, and two, where only pardonable errors which can be explained through affidavits and documents have been established. My Lord, those are the two circumstances before you. You can make an informed decision based on the material before you. On the converse, my Lord, in what circumstances can scrutiny and recount be granted? There are only three circumstances where scrutiny and recount can be granted. My Lord, this is to be found in paragraph 75 of the Supreme Court case of Nadif Jama versus IBC. My Lord, there has to be a dispute as to the election results. The petitioner has not challenged the valid votes in Form 35A. The second circumstance, my Lord, the same must have been signaled in the petition. There is no such signal in the petition. And in the final circumstance, basis must have been laid. The entire basis for the petitioner's quest for scrutiny and recount is that MCA votes were less compared to MP. My Lord, we rely on the case of Ayera versus Kimomi, where it was held that the High Court is gazetted, where a High Court is gazetted to listen to an election petition, it is specific. The court cannot...
Did you say Kimomi?
Kimomi versus Ayera versus Kimomi. My Lord, the paragraph... My Lord, we have violated paragraph 24. So the court can only listen to an MNA petition and not MCA. My Lord, on the issue of Kemskit, we have again highlighted it in paragraph 28 of the case of Ayera versus Kimomi. There was no any pleading, there was no complaint regarding the TLSKs and the PSDs in this particular. My Lord, we pray that this application will be dismissed with cause to the third respondent.
Not with your permission, kindly. Just 30 seconds of that. Just 30 seconds for one issue. Just 30 seconds, please. As it finishes, Shadrach, to just address it on something for 30 seconds.
My Lord had given an indication as to time, and we actually fought to comply so that
Okay, so no other party sought an extension.
Yes.
So since he's seeking for 30 seconds,
Yes.
I'll grant 30 seconds.
Most obliged, my Lord, I associate myself fully with the submissions made by my senior Mr. Moturi. My Lord, scrutiny or recount application should not be granted as a matter of course.
Until repeating, I thought you are telling me something new.
No, my Lord.
Your 30 seconds will go before you
Yes.
tell me what you are saying.
My Lord, a party should not be allowed to approbate and reprobate before a court. So that, my Lord, the basis of whether a scrutiny application should be allowed is based on the evidence that the court has since collected in its proceedings.
Yes.
My Lord, the entire case of the petitioner has been to treat the court to a confusion on the transposition of results from the A's to the B. So that the dispute as to the results is clearly discernible from the proceedings of this court. And lastly, my Lord, through his counsel, having so abandoned the scrutiny application, that in itself should be a guide or a further guide to the court on whether that application itself should be entertained. And to echo the sentiments of my senior, Mr. Nyamira,
You are now on the board.
yes, my Lord, the last one, my Lord, to echo his submission, in the absence of another oral or formal application for a review, the court should treat its record as sacred and be bound by it, my Lord. Thank you. I thank the court, my Lord, for its generosity to us and for the third respondent. Thank you, my Lord.
My Lord, if I get 2 minutes to respond to whatever issues are raised.
You will respond in report.
Thank you, my Lord. Thank you, my Lord. Mr. Kale submitted the documents speak for themselves. My Lord, it's the petitioner's contention that document includes the ballot boxes for which the petitioner seeks scrutiny. My Lord, there was submissions, and you are referred to some section of the regulations that refer to a prayer for scrutiny being specifically pleaded in the petition. In Gatirau Munya, the Supreme Court,
It was addressed. Somebody replied.
the Supreme Court held.
With regard to the regulations, I did not address that.
You see, you cannot say I'm addressing now. I remember somebody mentioned the Munya case.
I did.
Yes, it was mentioned. So proceed, Mr.
My Lord, it's been held that the affidavit in a petition forms part of the petition. I'll invite you to look at paragraph 42 of the petition, of the petitioner's affidavit.
Paragraph?
42 of the affidavit in support of the petition, and my Lord will notice that the petitioner has in the petition indicated that he will be seeking a recount and scrutiny of the votes. My Lord, if you are to look at the Ayera versus Kimomi is also Nyaribo, decision that my colleague has just referred to, in that same application, my Lord, in that same decision, the court did allow prayers for scrutiny and recount in this decision that my colleague Mr. Moturi has given to you. My Lord, finally, and let it be clear on record, my Lord, that even when counsel abandons a prayer, and I did not abandon, I could not, the court has to make an order that this prayer has been abandoned. Do not be misled by my colleagues, my Lord, to make a finding that the prayer for scrutiny had been abandoned when you did not make an order that it had been abandoned. You are the final man in this courtroom. It's not myself or my colleagues. You never made an order. So disregard. So, my Lord, disregard. I'm
Just
done.
like that, please.
I was, my Lord, just finishing that. You are the big man. You are the final person.
You can't see how I am.
You, to the people in this courtroom, my Lord, you never made that order. They are just telling you that counsel, so that I am not the court. I
If
could
you are not
not.
saying anything extra,
Thank you.
may capture
Thank you, my Lord. I'm done with that. I'm done with that. And possibly, my Lord, off record now, as you give us directions, I'll be requesting that you give us and give my colleague an opportunity, Mr. Kali, to indicate the status of whether he's confirmed the position with regard to the ballot box KOD2.
I thought he gave us a response on that.
He has not.
No, he did. He did, and it's on record.
What response did he give?
Tuachane na hiyo. Tulipewa response kitambo na iko kwa record. I think let's agree now on the way forward. Niombe dari ndio niangalie naona so that we had marked this date. Sorry,
Until next week Friday.
until next week
We
Friday.
were to start on the 24th, to Friday, Tuesday.
I just wanted to see when I can write the ruling and deliver the same. Okay. Sorry, next week will start on 23rd. Yeah, on 23rd I know it was not marked, but I know since I have only rulings and judgments the other side, I'm trying to see when I can deliver the ruling. Because we have to realize time is running out for us. I can deliver the ruling virtually on the 26th. Ruling on 26th. And then thereafter give directions that may be a consequence of it. So we'll do it that
Shall that include,
Sorry?
shall those directions include the finding of sufficiency?
Yes, you know, they'll have to flow from the ruling, because if I allow the application, we'll have to factor in the time for that exercise. If I don't allow, then again, we need not take a lot of time, but we'll agree. But you know, I know you will start making us final submission draft, awaiting the ruling, because also you will have to input
We're not allowed to kindly request for this administrative issue.
Yes.
My Lord, we do know that transcription is going to take a bit of time.
Yes.
If we could kindly be supplied with the copies of the proceedings, type proceedings.
I not the typing the proceedings, only that I don't know whether they've done the proofreading. Typing, I know yes, it's been done, but have they proofread? Because I do not want you to be supplied with typed proceedings that have not been proofread.
Since we have been in attendance, I think we would not mind, because we are not going to use it anyway. It's going to be a sketch guiding us on how we're going to do our submissions. And number two, my Lord, I know this is maybe for your directions. We have parties that since abandoned calling witnesses who have their affidavits on record. And my Lord, so that for us to move on and go forward in a good manner and systematic, I'm making an application that all the affidavits that witnesses who are not listed be expunged from the record. So that
I know that's clear. You don't even have to make the application.
the reason why I'm making that is that even what we are dealing with right now about a submission
that is called abandoned torture.
Yes.
But you know, evidence, I mean, affidavit that has not been adopted as evidence is not evidence. You remember the famous decision by Ringera J?
out of abundant question.
Okay, out of abandoned caution, I'll just I'll record it.
Your Lordship, I wish to oppose the application.
Sorry?
I wish to oppose the application, especially in relation to
Which application?
that one for strike now.
If you oppose, the law is very clear. Evidence, I mean, an affidavit that has not been adopted as evidence is not evidence. That is the law, and it's very clear. We are not reinventing, and that's why I was even telling you, he doesn't have to make that application.
Yes, for the record.
Hiyo sitaandika na nani. Na kuna vitu vingine. Usually nataka niandike that nili. Na ukiangalia say to age, hakuna mahali nyingine. Sasa hii unataka tuandike. And we have say evidence, affidavit, or even pleadings. Yes, okay. And it has been followed several over time.
Mr. Nyamira has been allowed to make his application. I'm only asking that he's allowed to
so that you don't be labeled. Unajua mahali is straight. Hakuna haja turudie pale.
I will only take 1 minute to just make
okay. You say you object.
I object to, there is an affidavit of a witness that did not call. The affidavit of Robert Ongaria for Bomondo 1, presiding officer Bomondo 1. And I wish there is an affidavit be adopted into evidence on the strength of section 33 of the Evidence Act.
Paragraph. Tell me
the affidavit.
No. Tell me which paragraph of 33 you're talking about.
Which paragraph of 33?
Of evidence, yes. You know that it's A to H. It gives instances when you can do that. I want you to show me the instance which we can do that. Yes.
But my Lord, I wish we could have just played safe because you said you are not going to consider affidavits that are not adapted.
No, since he wants it on record, let me tell me the paragraph. Probably I'm not aware of the paragraph.
Section 33, paragraph B.
Yes, read it as to us so that your colleagues can also have.
Let me read it.
Yes.
Statements, written, oral, or electronically recorded, of admissible facts made by a person who is number 1, dead, or who cannot be found. In this instance, he can't be found, or who has become incapable of giving evidence, or whose attendance cannot be procured, or whose attendance cannot be procured without an amount of delay or expense, which in the circumstances of the case appears to be to the court unreasonable, are themselves admissible in the following cases. A, relating to cost of debt, that is not applicable. B, made in the course of business. This is the one that I am basing on it. When the statement was made by such person in the ordinary course of business, and in particular, when it consists of an entry or memorandum made by his books or records kept in the ordinary course of business, or in the discharge of a professional duty, or of an acknowledgement written or signed by him of the receipt of money, goods, securities, or property of any kind, or of a document used in commerce, written or signed by him, or of the date of a letter or a document usually dated, written, and signed by him. On the basis of that section, that you may allow the editor, Robert Ongaria, to be admitted without comment.
Mr. What do you say to that? Because
the veracity of that affidavit has not been challenged through cross-examination. The witness has not come to court, sworn, and admitted that affidavit as part of the evidence. My Lord cannot therefore admit that affidavit as part of evidence, because all that my colleague has done is give evidence from the bar about the unavailability of that witness. That is an application, my Lord, that even without my response ought to have been disallowed. So much the court kindly disallow it, my Lord.
My Lord,
oh, sorry, for the bar, I don't know who.
My Lord, firstly, this software, we are supposed to be Siamese with,
Sorry?
we are supposed to be conjoined Siamese with my counterpart, this software. But in relation to the items that have been read out as regarding section 33 of the Act, my Lord, none answers to the situation that the first and second rescue find themselves in. Reason is, there is no material that has been presented before you of either them being dead, or not being available, or not being reached to come and tender evidence, or not being shown the amount of resources that can be put for them to be brought to court. And this is not a profession they were applying. It was an activity which was running after a specific period. They are not professionals in terms of the engagement they had. So none of the provisions of section 33 answers to an issue where this affidavit may be admitted into court. And further, the state affidavits have not been tested by way of cross-examination, by way of adoption and cross-examination of those witnesses. So, Lord, let the record indicate, out of abundance of caution and on the Nyamira authority, that they do not form part of the record. This is way forward. When I'm not there, we're not there on the file, we will have something to cling on to that they were expunged, and only those witnesses who testify are the ones who have had their evidence given. Thank you.
Mr. Kali, 1 minute.
To answer Mr. Choki, yes, indeed, they have not been cross-examined. That witness has not been cross-examined. Now, the issue of cross-examination goes to the weight, the probative value, not admissibility. These are different. I am saying the statement should be admitted. As to the weight to be given to the statement, the court will determine, given that it was not cross-examined. And given that is evidence related to documents that speak for themselves.
Section 3 of the Evidence Act is very clear as to when such evidence ought to be admitted. The evidence of the same witness does not fall in any of the exceptions. There was no attempt to have the same witness testify back. Probably had this been done, the present application could not be necessary, or rather would not be necessary. The application is therefore dismissed. All the affidavits filed herein and where witnesses did not testify are hereby ordered expunged. The counsel for the parties may be supplied with typed proceedings at their expense.
As you stand up about
Before Mr. Nyaberi addresses you, I was just seeking a clarification as to the time of your ruling on the 26th.
Yeah, I'll give that this, let's finish off with the issues. I'll give the time.
Thank you.
So that we all read from the same script.
Thank you, my lord.
Yes, Mr. Nyaberi? You wanted to say something?
Yes, my lord, as regards petition number 1, we wish to sincerely thank the court for the guidance and accommodating us even when we went overboard.
Sio tuseme tukimaliza kazi.
We are making it.
Oh, you are bringing it in advance?
In places.
Okay.
And with the request and agreement of all of us, my lord.
Okay, sawa.
We really appreciate, my lord, for the time that you have afforded us. We know we went overboard at times. It is the call of duty. And to councils also, I wish to extend my gratitude to them. And we thank the court and we wish the court well as given the directions as to the way forward. My Lord, the second is that once we are done with this file, there is a matter in file number 3 that was filed.
Yes, I'm aware.
And maybe as we wrap up on this, we may want to kindly.
Once we are done with this, I will handle that. And even I have also another link to take.
Thank you.
So, thank you for the compliment. I know it's not usually easy, and I know at times we love us, but this is duty. When we correct each other, and at times we
possible that it can be slightly earlier than 9 o'clock?
You know why I'm saying 9? Because I know there will be other issues following the flow, flowing from the ruling.
Or even in the afternoon?
It in the afternoon, tufanye asubuhi.
Right,
If that date is not convenient, we
no,
better
it's
take
okay.
another date.
We can do the 26th. I was just trying to see how we can work, separate this.
Ruling, sorry, morning will be better. When we
That's
are all
fine.
fresh, we are not bogged by other works, so that whichever way the ruling goes, we can be able to take other directions.
That's fine.
And then be free to do other businesses, other than waiting in the afternoon. I don't know, unless the date is not convenient to you guys, I can still give a different date other than that.
It's fine, my lord. We can do
26, because I'm trying to, I don't want to push it to Friday. I'm trying to make sure that by God's grace, before March, I would have rendered judgment before March. So that if any party is dissatisfied, because there are two parties, and the ruling, the judgment will favor one, definitely it can't be a draw. You know, in court, there is no draw. So that if a party wants to appeal, they will have that time. So if we are agreeable, I will put the time as 9. Any other voice of objection? Okay, not really objection. Request of a time change?
Mr. Chair was saying 27.
Sorry?
I don't know why it's square. 26 is okay with us.
Mr. Chuck? You are suggesting
I know that my diary next week is just bad. That's why I was saying that
but
we
we have
come
booked it for this. In fact, up to 27. That's why I have picked on the date we had beat.
You'd given us an opportunity to possibly give another opinion. Can we do Friday, my lord, at 9 then, 27? It's not too much to ask.
Or we move back. You know, I'm also trying to, I don't want to push it towards that end. Because I want, God willing, before March. You know, this time bound.
It's okay. We can work then, my lord, with the dates you've given us.
Then probably we can change time. If it's agreeable to the other, or we stick to 9.
9 is okay.
9 is okay. Mr. Choki, wacha tufanye. You see, time bound, tusisongeshe huku afadhali
It's okay,
turudishe.
my lord. It's fine, my lord.
Actually, then the end, my lord, we could have been here, I did not cut on the witnesses of the court.
Yes, that's what I'm saying, and that's what I was alluding. So we agree at 9, tutapata copies ya na mjue hata itakuwa na mistake hata yangu. Unajua wakati mwingine tunaandikanga ukisoma ndio unajua hapa I meant to say this. You're correct.
Can we get the copies on our email, my lord? Or we need to?
I don't know, you will have to talk down to the, that is administrative. The PR will facilitate that.
He's present, my lord.
Order. Hizi wasilete zitapakiwa pamoja yako after done the necessary. So I think let me now address election petition number 3 and mwambie wale wajitayarishe. Immediately I'm not writing, I'll just finish this and then take it. All right, let's go to election petition number 3. This, I believe, is for the elections.
Yes, my lord.
Who is for Mr. Mugakori is for the petitioner and is absent? Sorry?
Yes, my lord, there's an affidavit of service, parties are served.
Okay, Mr. Mugakori for petitioner, absent.
Yes.
And for the first and second respondent is Mr. Kali.
No, there was an advocate.
Oh, okay, sorry. Oh.
Another matter in the High Court.
Oh, the advocate, sorry.
Yes.
There was an advocate
Yes.
who sought to address me nikawambia
Yes, yes.
angoje tuendelee na
Yes.
hii.
I don't know where.
Because he cannot stop me midstream and start addressing me on
My
another
lord is
matter.
outside. He had a matter in the High Court, virtual matter.
Si kama mtu atampata so that I don't ask you to come.
My lord, even there the quorum, the quorum should just indicate that no appearance for the petition, not Mr. Mugakori, because we don't know whether.
That's what I've written. He's absent for Mr. Mugu. But I'm talking of the other
So
council.
I'm saying the name, it should be no appearance for the petition. Because Mr. Mugakori has been briefed.
We don't know, but the record still says is for the petition. So we go by what. Umetumana angalia huko. Meanwhile, Kakoras, that's with the light touch, of course. Now, you see, who was for the second and third? Let me just consult. How many yuko?
Yes, that's
Oh,
the-
he's the one. And then for the third respondent,
My Lord,
Miss
Moe?
Miss Moy. Oh, the entire family.
Yes.
Miss Moy, Mr. Nyaberi,
Mr. Mokua?
Mr. Mukua,
Mr. Wambui?
Mr.
Wawambui?
Wawambui, Wawambui,
Mr. Asuma?
Mr. Asuma,
Asuma?
Asuma,
Mr. Omayo?
Mr. Omayo,
And Ms. Oduwe?
Miss Omoyo. I wish angekuwa traced tumalizane kabla ndio nisiwaweke hapa sana, because I just want to take the plea. Can somebody try and find out if he's still held up in court? I can be taking the plea meanwhile. But I think this one is just for direction, isn't it? Yes. It will not take us many minutes, but it's good that we wait for him. Nimeona Mr. Asuma ameenda, wacha tusubiri kama atakuwa njiwa ama atakuwa, which bad was that? Sikumbuki.
Come with some grass.
Okay.
Perhaps my Lord, suggest that maybe you continue to take the plea.
The problem is wamejaza nini hawa watu wenu, people before the state wamejaza doc. Unajua sasa hivi tukigombaniwa, nyinyi mnakiwa accused 1, 2, 3, 4, 5. Okay, the accused is here.
Yes, Lord.
The prosecutor.